the Honourable Minister for Labour, Industrial Relations and Employment. Members of the Bar and the Law Society, ladies and gentlemen. A very warm welcome to you all. We are writing a new chapter in the history of this arbitration tribunal. Mauritius achieved independence without bloodshed. However, bad blood prevailed. Several countries had already gone through post-independence industrial and agricultural tribulations, as well as business stagnation coupled with massive unemployment. 1968, we were not an exception. Strikes in the sugar sector, which used to be our main export, the transport sector, our ports and docks, electricity supply, and educational sector were evidence of growing industrial dissatisfaction. Ad hoc tribunals were set up to arbitrate industrial disputes, and I have had, Honourable Attorney General, ladies and gentlemen, the fortune of knowing one dignified Chief Justice, Sir Henry Garrick, who was called upon to arbitrate industrial disputes, both in his capacity as judge and as private arbitrator. He predicted at some stage that the Permanent Arbitration Tribunal would become an expert institution with time and experience in the sphere of industrial relations. Indeed, the time for an added jurisdiction to this tribunal's existing aura has come. The Employment Rights Act now makes provision for the creation of an Employment Promotion and Protection Division within the tribunal. It shall deal with all cases of reduction of workforce, whether on a short term or permanently, or the closing down of an enterprise referred to the tribunal by the Ministry of Labour, Industrial Relations and Employment. For the purposes of this new division, the law defines the word employer to be one of not less than 20 workers. An unjustified reduction of the workforce will entail either the reinstatement of the worker to his former employment, and that with his consent, or the obligation to pay to him severance allowance. The new law also introduces the principle of last in, first out, that is, the last one recruited to be the first one through the exit door. The tribunal has only 30 days with an extra 30 days in exceptional cases to consider whether the employer's decision is justified. The time limit is itself a challenge, the more so as the tribunal has to take into account the constitutional and other legal rights of parties. In that respect, we would welcome lawyers' understanding to assist the tribunal in meeting its deadlines. We also believe our electronic system, installed some 2 years back, will contribute in expediting matters. The Employment Promotion and Protection Division will be presided by the President or the Vice President of the Tribunal, together with 2 members well versed in the field of employment relations and finance respectively. Ladies and gentlemen, thank you for attending to my summon this afternoon. I will now leave the floor to the Honourable Attorney General. Thank you.
My colleague ministers, Honourable Shakil Mohammed, Minister of Labour, Industrial Relations and Employment, Honourable Jim Sitaram, Minister of Business, Enterprise and Cooperatives, my good friend Rashid Hussain, President of the Employment Relations Tribunal, the Vice Presidents of the Tribunal, Senior Counsels, Senior Attorneys present with us this afternoon, colleagues of the legal profession, ladies and gentlemen. I'm privileged and honored to address you on this occasion. It is interesting to note that the Permanent Arbitration Tribunal, PAT in short, now known as the Employment Relations Tribunal, was set up back in 1973, following the enactment of the Industrial Relations Act 1973. It is noteworthy that this institution is reckoning its 40 years of existence this year. Allow me on this occasion to commend the President, Mr. Hussain, and the staff for this institution for continuing to endeavor in the interest of workers and all related stakeholders. Let me take this opportunity to also place on record the very important role and contribution of the Employment Relations Tribunal in the settlement of industrial disputes and for the promotion of harmonized industrial relations in the country. Ladies and gentlemen, in the government program 2010-2015, government indicated its strong commitment to ensure that decent work conditions prevail at the workplace. Also, it was mentioned that government will relentlessly pursue its policy of protection of workers and the promotion of social dialogue. In this regard, the Employment Rights Amendment Act 2013, or may I call it the Mohammed Bill, was passed in the National Assembly in April this year, and it provides for the creation of a new division of the Employment Relations Tribunal, to be known as the Employment Promotion and Protection Division, as rightly pointed out by my friend Rashid Hussain. This measure aims at bringing changes to the employment legislative framework that is compliant with international labor standards. As I indicated earlier, the Employment Relations Tribunal was established in February 2009, following the merger of the Permanent Arbitration Tribunal and the Civil Service Arbitration Tribunal. The establishment of the EPPD is yet another clear indication of government's commitment to protect the interests of workers and safeguard their rights. I must here highlight that this division has considerable powers in relation to cases of redundancy or closing down of enterprises. There's a strong reason for setting this division within the ERT, since government wants to ensure that there is an independent, impartial and independent respected body. I'm confident that this body has the required expertise in employment relations matters to deal with such important issues which may have a bearing on the lives of numerous workers and at the same time on the country as a whole, in terms of investment, both FDI and local. To handle such an important responsibility, which is a careful balancing exercise, government has placed its trust in the ERT. You are aware that the ERT comprises of a president and 2 vice presidents who must be qualified for appointment as judge of the Supreme Court. They are assisted in their deliberations at the level of the EPPD by members with proven experience in the field of employment, relations and finance respectively. Ladies and gentlemen, you may be aware that before the amendments brought to the Employment Rights Act, any employer intending to bring a reduction in the number of workers or to close down his enterprise for reasons of any economic, technological, structural or similar nature had only to give a written notice to the minister. He or she could basically proceed with the termination of employment and pay a recycling fee to the National Savings Fund. There was no mechanism to exercise any control on the reasons provided by any employer in effecting the reduction in workforce. It is also noteworthy to point out that under the defunct Labour Act, any employer of not less than 10 workers who intended to reduce the number of workers in employment either temporarily or permanently had to give a written notice together with a statement of the reasons for the reduction. Upon receipt of the notice, the Minister had to refer the matter to the Termination of Contracts of Service Board, TCSB as it was used to be known, to determine whether the proposed reduction was justified or not. I'm also given to understand that the principal reason for the setting up of the Employment Promotion and Protection Division is that since the coming into operation of the Employment Rights Act, government has noticed that employers had been making an abuse of the situation. They have been putting forward the argument of reduction of workforce whenever they wanted to terminate any employment. This has been strongly criticized by trade unions, who considered that the current process of termination of employment was working too much in favor of employers. Ladies and gentlemen, it is relevant on this occasion to highlight some salient features of the amendments that were brought in. The law provides that an employer with no less than 20 workers who intends to reduce the number of workers in his employment, either temporarily or permanently, or close down his enterprise, shall give notice of his intention to the Permanent Secretary of the Ministry of Labour, Industrial Relations and Employment, together with a statement of the reasons for the said reduction of workforce or closing down. The submission of the notice shall be done at least 30 days before any action is taken by the employer. The law also provides additional safeguards which the employer has to comply with and include mandatory consultation with recognized trade unions to explore other avenues available to the employer to avoid the reduction of workforce or closing down of the enterprise. This is something new which didn't exist before amending the legislation as it then was, where despite such consultations, reduction of workforce or closing down seems inevitable. The employer has to comply with principles such as last in, first out. It was mentioned earlier by the President, Mr. Rashid Hussain. Provision is also made for the employer and worker to come to an agreement on the payment of compensation by way of a settlement. This allows greater flexibility and better employment relations, since parties may come to terms at an earlier stage whilst avoiding long and strenuous proceedings which may not be beneficial to either party. If there is no settlement, however, the worker may join the workfare program or register a complaint with the Permanent Secretary of the Ministry. The latter shall inquire into the complaint with a view to promoting a settlement between the parties. Should this fail, the worker may, and again this is a new provision which was not there before, if he has a bona fide case, he can have recourse to other alternatives available to him, such as joining the workfare program or even institute proceedings before the industrial court to claim severance allowance. In these circumstances, the matter would not be referred to the tribunal. However, if he does not institute proceedings on his own, the matter will be referred by the Permanent Secretary of the Ministry to the tribunal. I must admonish that the tribunal then has to proceed diligently. It has to hear the matter and give its award within 30 days of the referral. This is a giant step forward compared to previous comparable provisions which existed under the repealed Labour Act. We have had the experience where cases referred to the then Termination of Contract Service Board would drag on and on for years until ultimately a decision in certain cases would become, unfortunately, merely academic. Also, that body could not order any reinstatement, as is the case now under the new law. The new EPPD is expected to complete these cases more promptly, whilst, of course, respecting the rights of the various parties. The EPPD may, with the consent of a worker, order severance allowance to be paid to a worker. Also, more importantly, it may order in appropriate cases, in the case of a reduction of workforce, that the worker be reinstated in his former employment with payment of remuneration from the date of termination of his employment to the date of his I'm informed of the considerable efforts being made by the tribunal, which is now an e-tribunal, to provide an efficient, modern, reliable and rapid means of arbitrating and solving disputes between relevant stakeholders. I have no doubt that the ERT will be able to rise up to this new challenge. I feel it is very pertinent to take note of what John Rockefeller stated once. I quote, he said, "I believe in the dignity of labor, whether with hand or with head, that the world owes no man a living, but that it owes every man an opportunity to make a living." End of quote. I thank you for your attention.
Thank you very much, Honorable Attorney General. It will not be fair not to call the Minister who introduced the bill in Parliament, the bill that made provisions for the creation of the Employment, Promotion and Protection Division, to address us a few words. Honorable Shakil Mohammed, please.
My colleague ministers, Mr. President, Vice Presidents, the members of the Tribunal, Professor Torol, colleagues of the bar, lawyer friends, ladies and gentlemen, if you wanted evidence of the independence of this tribunal, I mean, look at it, it's just got the MBC now in the box there. So I find that's a good start. And there is something else I wanted to say, Mr. Hussain. It is not because there are certain trade unionists who do not like coming to this tribunal that I propose that in the law it is this tribunal that shall see the creation of this new division. As you all know, there are certain trade unionists who do not like coming before this tribunal, and this is not what really made me take that decision, no. It's the first time I come to the tribunal. Thank you very much for the invitation. One of the reasons I've always not wanted to come to the tribunal is not because I have anything against the tribunal or anyone here. On the contrary, it is I have a lot of esteem and respect for the work that is done here and for the members of this tribunal, the Vice President, the members, and you, Mr. President. And I did not want anyone to ever say that there is some sort of conflict or some sort of unwarranted mingling between a member of the executive and this tribunal. And it's par respect pour l'indépendance de ce tribunal. I did not want to give the impression that there was anything wrong. That's why I've never set foot into this tribunal. Now that you invited me and insisted and had so much difficulty in reaching me, I admit, I have come over because it's true. I had a lot of work I had to put in to prepare this bill. As my friends, my colleagues, my brother ministers would recall, before I finally came to Parliament and had this bill voted, and now it's an act of Parliament. I never thought, when I was member of the bar, when I was a lawyer, that I would one day have gone to Parliament and brought a bill and precisely in the employment relations and rights issues. But it is something I'm very proud of having achieved. But let me underline certain very important facts. We have had many months, hours of consultations before preparing the final version of the bill. The former director of Labour, Mr. Ramsamy, is here present. Mr. Ramsamy here, and I acknowledge his presence. He was, with me, one of the officers who really advised onto how to make things move forward. And one of the things I did ask him, as then director of Labour of the Ministry of Labour, was, "You're about to retire," I said to him, and surprise me. "Do come up with suggestions and proposals that you would never even dream of suggesting to any other minister in the past. Because always there are certain realities that are very difficult to achieve. You want to do certain things, but you can't. Because some people may call them scandalous, some people may call them revolutionary, some people may criticize it. But I asked the Director of Labour to come up with such proposals, and he did. And I thank him for that. He was in Australia at the time that this matter was called in Parliament. He had already retired. But he is one of them I'd like to openly thank for having brought about such, in my view, historical changes in our labour legislations. The International Labour Organization was not very happy, I must admit, and I'll say it openly, that I brought in the concept of last in, first out. They wrote a report where they said that I should not, as minister, bring that in our legislation. They thought that it was discriminatory. Interesting. It's a moot point. So now that I've said that, I'm sure there are certain lawyers who would maybe take it up. And I'm all for it. Take up such issues. I don't think it's discriminatory anyhow. But then again, they said that in the United Kingdom such an issue was being decided or argued before a court of law. And they thought that this was a matter that would create jurisprudence, and therefore I should halt and not come up with such measures. And I agreed to disagree. I do not believe it's discriminatory, and I came up with that because every single day as Minister of Labour I receive those notices that the Attorney General has referred to. Employers simply send me letters. We are hereby firing so many people for economic reasons. We do not have the staff at the level of my ministry and the expertise to verify whether or not real economic reasons or structural reasons do exist. We could use people from the National Remuneration Board and their experts to help us, but we are not staffed. That's one of the reasons why we created this new department, this new division at the level of this tribunal. Every day I receive those letters. And we talked about the recycling fee. Yesterday I received a report from the Ministry of Social Security. Ever since the proclamation of the Employment Rights and Relations Act brought then by the then Minister of Labour, Honourable Banwari, 5,000 cases of non-payment of recycling fee exist. 5,000 cases of non-payment of recycling fee exist. 5,000 potential criminal cases under our legislation. 5,000 cases for the Ministry of Social Security to claim that recycling fee. 5,000. That money belongs to the workers of this country. That's money that employers have failed to pay into the system. Those are employers not playing the game, and those are employers acting wrongfully against workers of this country. So I have taken this opportunity here today to state openly, we are going to give enough time until the end of September for all employers, those 5,000 cases, to pay up. And if they do not, every single one of them will find criminal prosecution against them. This is the extent of our resolve. We will not back down. We will not sit quietly and watch things like that happen. Because people in this country have to understand, when you are in government, trade unionists believe that we have to only look on one side of the fence. We do not. We have to forget about the employers. Employers believe we only think about productivity and profits, and we do not have to think about decent work and decent wages for employees. The tribunal has that difficult task. an immense task. We as a government we have to draw the line. It's a balancing exercise that is very difficult to achieve. And we have tried to do it, and I am of the humble view that we have succeeded in doing it. Now what we require is not only that it be implemented at the level of this tribunal, and I'm sure, certain, that it will be. It now also depends on members of the legal profession to help that we develop the law, implement the law, and as Mr. President, you have said, there is a time factor, not like at the level of the termination contracts and contract service board, where people, I remember when I was joined the legal profession and the termination of contract service board still existed, there were cases that were still being discussed there by my father, lawyer, when I was still at secondary school, and I had already become a lawyer. I was in shorts at Saint-Esprit. And I was already a lawyer for 2, 3 years or 4 years experience, and the matters had not been disposed of before the termination of contract service board. So we have now set time limits. It's because workers want solutions. The country needs to move forward. Employers also want to know what exactly is the state of affairs. We cannot let things drag. We cannot therefore, let me say it upon me, we cannot therefore ask, like I used to do, ask for postponements or things like that. Let me take it upon me. We should not do that. Don't follow my example. Don't do that. And in any event, I had the honor of appearing before Mr. Hussein, who was then magistrate, and whenever I did ask for such unwarranted postponements, believe you me, he has an ability of refusing it, and I had to agree with him whenever he said so, because he was always right. So I'm sure that things will work well, but we all have to work together to ensure that the delay that is prescribed in the law is adhered to. Because without that, it does not make any sense to have created this new department. So thank you very much for having invited me. I think there is a lot of work and a lot of good work ahead. I would also like to say to all members of the tribunal, you have a lot of work cut out. Now that the notices were being sent to me, I'll be able to send it to you. And you will have to come up with the answers. And I only would like to send another message out to the employers. A lot of them were abusing the situation. A lot of them were thinking that they would just choose to fire people on economic reasons or structural reasons, when those reasons did not exist. Now the time has come for you to face up and establish that there are economic reasons, without which you will have to reinstate or cough up, pay the worker. Thank you very much.
Thank you, Honourable Minister. When I was referring to the 30 days, I was complaining, having to probe so much into such little time. Vous faites louper les pots cassés des autres